All right. The conversation right now is about the local government administration in Osun State, which has been grounded for quite some time now. There is a background to that. There are issues about who is in charge, who isn't in charge, court cases, a judgment that have been delivered January 13th, even before this year, February 10, June 13 as well. That's the latest when the appeal court refused to release the case called by some appellants, including the APC as well. But APC, following the February 10 election, some of their men have taken over the councils. Some say is resumption of their duties because that February 10 judgment returned their mandate to them. But Osun Pdp and the Osun State government is saying, no, you people, you are just breaking into the local councils. Election was held on February 22nd. We produced winners, all of them of the PDP, and they have been sworn in by the state governor, Ademola Adeleke. He told them, please stay away to avoid what happened, after the February 10 declaration. Court of Appeal judgment in which, in the process of trying to go back to the councils, issues happened, 6 or 7 persons died, and the governor said, please stay away, but you guys are the authentic ones. But the APC are saying that is not what the court said. We are being reinstated. The PDP and the handlers are saying, where was it written? You guys are interpreting what is against the law. Then the release thing issue happened, in which the case was dismissed, and the Court of Appeal judgment refused to take that release day. But the APC have come out to say whatever happened, it has nothing to do with what is on ground. We are the ones in charge. Now, the All Progressives Congress Osun State on Monday said only the Supreme Court can invalidate February 10, 2025 appeal court verdict that reinstated its members to take control of councils in the state. The opposition party noted the fresh dismissal of another suit on local government at the appeal court in June 2025, and they said it never invalidated the earlier verdict by the same court. And a statement by the party through its state legal officer, Chief Adegoke Ogunsola, warned the Osun State government, the governor, Ademola, Adeleke, the PDP, against inciting the public and court against their reinstated ESCOs. And he said, let me quote him, since the DOE lost the control of the local government administration in Osun State following the judgment of the Court of Appeal of 10th February 2025, they have resorted to all manner of desperate antics to cause confusion in the interpretation of the Court of Appeal ruling of 13th January and the judgment of 10th of February 2025. It went further to say the latest act of mischief unleashed by the governor and his party men were caused by the latest decision of the Court of Appeal of 13th June 2025 refusing to release the appeal of the APM and the All Progressives Congress APC. And the major reason for the refuser to release the appeal is that the same Court of Appeal had decided the same issues raised by the appeal, and they said, we urge security agencies and agents to ignore attempt of desperation and harassment by the government of Mr. Ademola Adeleke and his PDP handlers to confuse the polity and then seize by the force of arms the local government administration in the state of Osun. All right, the man who made those statements for the Osun APC is here with us, Barrister Adegoke Ogunsola, the state legal officer for the Osun APC. Good morning, sir.
Yeah, good morning, Nigerians.
Good to have you here with us.
I'm happy to be here too.
Right.
Thank you for joining us.
Yes.
And this is your position, and of course, the position of Osun APC, that only the Supreme Court can invalidate appeal court verdict on restated ESCOs. How did you arrive at that?
Very well. I'm happy to be here once again. What is actually happening in respect of the local government administration in Osun State today is worrisome. It's worrisome in the sense that we have judgment and rulings, but it's unfortunate that the parties involved choose to have a different interpretation. Why the PDP and the Osun State government, through what I will call mischief interpretation.
Mischief
Interpretation. had twisted the import of the rulings of the court and the judgment of that particular court of appeal of Akure. What we need this time around is purposeful interpretation. And if we fail to embark on purposeful interpretation, we're bound to have the problem we have at hand. What I mean by that is that when you go to court of appeal, you go with some reliefs. And once your appeal is allowed, those reliefs have been allowed. There is no need for the court of appeal to make specific statements unless it is a criminal matter where somebody had been convicted and they wanted, that particular person wanted the sentence to be reversed. It is then that there could be specific pronouncement. But once the court says the appeal is allowed, then all the reliefs you sought for are allowed. That is purposeful interpretation. But in a situation whereby you insist that there is no express statement that those who went for appeal should be reinstated, then we embark on mischief interpretation. And there is bound to be problem if you choose such mischief interpretation. It is clear, February 10 judgment, the court said the appeal is allowed, that you shouldn't have even gone ahead to institute the case. It means that you return back to the status you had when the election was held.
Is that written in the judgment?
You don't need, that is why I said purposeful interpretation.
What do you mean?
You are still interpreting. That's your own interpretation.
Purposeful, we have different, where are the jurisprudence?
Yeah.
You have different types of interpretation. One of it is mischief. The other one is purposeful. And the purposeful is the one that is useful to the society. When the appeal is allowed, for goodness sake, is written in simple English. What will follow?
Barrister, how can you adjudge that your own interpretation is purposeful and the interpretation from the other camp is not purposeful? It's now based on opinion.
It's not opinion.
Because since it's not written as fact in the judgment,
it's clear.
You are saying your own interpretation is purposeful. How can you judge yourself as being
in the
purposeful?
Judgment, you agree with me that it's written there that the appeal is allowed. In the judgment. Isn't it written?
Which judgments?
The judgment of 10th February.
Talking about your court of appeal. How about your case that was struck out because of want of diligent prosecution for 2 years? That is
why we are having illiterate interpreting judgment.
That was interpretation.
Go and read the judgment of Obiora, Justice Obiora, at the concluding part. He said the same subject matter, the same party, and the same election, the same fact, had been litigated upon and decided by this court. In appeal number so, the appeal I referred to, in which judgment was delivered on February 10, 2025. And he said that particular application was an attempt to invite them to review their judgment. It is only the Supreme Court that can do otherwise on that particular judgment. There is nowhere in any jurisprudence or in any jurisdiction of court that will invite the same court of competent jurisdiction to overrule itself. You go upstairs. You know the motive behind.
I want you to address that particular one that was struck out because of want of diligent prosecution.
Yes.
What's the implication of that? How do you interpret that?
Yes, you don't need to interpret it. The court has pronounced on it. But Justice Obiora has done very wonderful job on that particular one, that you cannot invite us to release that particular case again with the view to rule on it again when a similar case had been decided. You can't do that.
The reason given was that you did not prosecute. There was no diligent prosecution.
That was the basis of the application. You are looking at the basis. You don't look at the conclusion. The basis is that when the two appealed.
But that was a relief. That was a relief you are seeking.
You know, I was involved. I'm a party in the one that in which judgment was given on 10th February. My name is clearly written there. I'm one of the appellants. So I know what I'm saying. What actually happened was that when election was held on 15th October 2022, before that particular election, the People's Democratic Party went to institute a case against those against the then Electoral Commission of Osun State. And in the course of this case, candidates were nominated. The notice had not been issued, the notice of election, before they went to court. So they thought they were being proactive so that the election would not hold. So they went to court. When candidates were nominated, PDP decided not to involve in the nomination and participation in the election. They now sought to amend their case to include our names, because I was one of the candidates. And in actual fact, I'm the current chairman of the Osun Local Government. So they now included our names there. Then our position through a preliminary objection was that the court ought not allow that particular amendment. They ought to have instituted a fresh case against us. But because they wanted to beat time, they were calculating that we had lost the election. And by November, Adeleke will be in government. So they wanted the judgment to be delivered at the exact time Adeleke will be sworn in. So instead of instituting a new case, they now amended, which is not allowed by law. Because the course of action had not arisen at the time they instituted that particular case. That was our position through a preliminary objection.
So the court saw it as speculative.
Yes, the Federal High Court overruled us and went ahead with the substantive matter. So, and judgment was delivered on 25th day of November 2022. And it was against us. Even at that moment, the governor was not supposed to sign executive order to order us to vacate. What the law says.
The judgment that was against you was the APM case.
No,
which
PDP
one?
case.
Okay.
The APM case was delivered on 30th after we had been sacked. It was not before our sack.
Okay.
It was PDP case that was delivered on 25th day of November 2022.
So you were actually sacked by that ruling.
But then you know that you don't need to ask me because it's clearly.
No, I want you to admit it, yes.
No, I don't need to admit it. I cannot deny it. I'm a lawyer. It's in the judgment. What is the essence of denying it?
No, I just wanted you, since you're here, I just wanted you to state the facts.
Instead of allowing us to stay and pursue our appeal, the governor now signed a midnight executive order on the 27th that we should vacate and the most senior officer to take over the charge of the local government councils in Osun State. It's never done. He was a product of court. When a judgment was given against him at the tribunal, nobody sacked him, the governor of Osun State. He was allowed to remain there up to Supreme Court when the final judgment was delivered that he won the election. The same thing is applicable in our own case. You should have allowed us. This thing had happened.
That you are supposed to have sit tight there and be appealing.
I'm happy. This is not the first time. When we wanted to take over the reign of government from PDP, we met PDP chairmen and councillors at the helm of affairs. And the case was in court. I was involved as a lawyer. I was not a candidate there. And when Adegoke came, Adegoke sought for the position of law. And we told Adegoke, we advised him that you cannot relieve them of their position until they pursue the right of appeal they have up to Supreme Court. And Adegoke allowed them, left them in their position up to the Supreme Court. It's interesting to note that it was 2 days to the end of their tenure that the Supreme Court delivered judgment. And nobody sent them away. So the same thing is applicable in our own case here. the governor should have left us, we pursue our right of appeal. If the appeal is against us up to Supreme Court, then he can sack us.
Barrister, are you saying that the governor does not have the right to use his executive power?
He doesn't.
Well, so you are trying to relate it with your own, with the governor's case.
He doesn't.
Which is different.
He doesn't.
Okay. Now he has used his discretion to say, since the court...
He doesn't have
Hold on, Barrister. Hold on, Barrister. Hold on. Since the court had sacked you,
yes,
the governor was simply acting based on that information to give that executive order.
He doesn't.
So that's his own discretion, his prerogative.
He doesn't have that prerogative.
Are you saying this by your own opinion or by law?
It's not my opinion. It's not my opinion. The court had ruled.
Yes.
Your election was not validly conducted. Then the law says you have right of appeal to the Court of Appeal. When you lose at the Court of Appeal, you have right of appeal to the Supreme Court. What the law says is that we have not exhausted right of appeal, and we should be there. You cannot execute. That particular executive order was meant to execute that judgment in which we had even lodged an appeal.
All right. Now, if we're going to be taking it one after the other, from where it even started from, some will accuse your party of running foul. That, in fact, this whole controversy was birthed on irregularities and, running foul of the law that your party that was in government at that time did by organizing that yes or no election with just a 2-month notice. By the way, that was, if actually you have gone through the thing you are supposed to go through, the right process, follow the law, we will not be here. That's one thing that, in fact, you should admit and apologize to the Osun people for giving a notice of 2 months to conduct a local government election against the statutes of, organizing such an election. So, Barrister Adegoke, will you apologize for doing that this morning?
That's not correct. We have moved beyond that.
No, there's no way I can. Hold on. You took your own submission from how the governor wasn't even supposed to sign that document.
We have moved beyond that.
Why are you not taking it back to where you started from?
We have moved beyond that. Because the same
But that was not supposed to be.
No, you cannot say that until they go to court and validly nullify that election.
You mean somebody can do something wrong and tell the court to protect him?
No, they go to court. They should go to court. Let the court nullify that election.
So you are not agreeing that what you did was bad?
I cannot agree until the court says so.
Okay. But you, as a lawyer,
I cannot because I have my position. When I get to court, I have my position.
All right.
If I apologize now, what will be my position before the court?
Yeah, you have a position before the court. You have a position as a barrister. You have a position as a Nigerian. And I think that's the biggest. You are Nigerian.
I'm a lawyer.
But you are Nigerian.
And I am a Nigerian. I cannot deny that.
All right, let's hold on, sir. Let's take it forward now to this June 13 election.
Yeah.
Let me read some
June 13 or ruling?
June 13 ruling.
Okay.
Appeal ruling. Read, yes, thank you. Read by my Lord Justice Peter Chudi Obiora, JCA, and some part of it, and I'll be quoting on page 45.
Okay.
Paragraph 3 to 46. It said, this is from my Lord Justice Obiora. It follows that beyond the third appellant, and by the virtue of that listing, the third appellant is the APC. It follows that beyond the third applicant as a party to the suit, there are some of her members who are directly affected by the judgment of the lower court by the virtue of their removal from office as chairmen and councillors of the local government councils that naturally would push the third appellant application to pursue the appeal diligently if the third appellant applicant was sincerely desirous of doing so. On page 48, my Lord continued and said, like I earlier observed, the third appellant applicant is a political party in Nigeria with members across all the states in Nigeria. In particular, the third appellant applicant has our executive officers and members in Osun State, particularly our members who are sacked as chairmen and councillors as a result of the judgment of the lower court and are personally aggrieved by the judgment. And he went further to say, if the third appellant and applicant and her members who were elected as chairmen and councillors and subsequently sacked by the lower court knew that the time of office they were elected to serve was 3 years, then it is inconceivable that they will go to slumber for 2 years. What do you make of that?
You know, the problem,
Lord repeatedly said
the problem is that
that was the same question I asked.
The problem is that when you have judgment rulings, people read part of it.
Okay.
And you seem to.
But these that I read were in that CTC.
No, you know.
They are there.
And you know, CTC,
and it was my Lord that said that.
CTC is popular now.
Yes.
In Osun State.
It's called the certified true copy.
Let me tell you.
Tell us.
When you have judgment or ruling, you have a holding or holdings of the court.
Okay.
You have obiter dictum. You have observation. You have review of evidence as well as facts. What you read is not the holding of the court.
How do you mean?
It's the observation. It's clearly written. That is not the holding of the court. Go to the holding of the court.
So
when you read the holding of the court is that I will refuse this application just because a similar case had been decided by this court, and if we release this case, is an attempt to invite us to sit on appeal on that particular case that had been ruled upon.
Barrister, for the sake.
Let me. I'm a lawyer. You are not a lawyer.
I know.
You are not a lawyer.
I know.
Hold on.
For the sake of our viewers, please hold on, Femi. For the sake of our viewers.
What I'm saying is this.
For the sake of our viewers.
Our lords, any court of appeal, either as the court of appeal, the high court, the magistrate, the Supreme Court, they don't use their words anyhow. You know.
That is why I said.
Hold on. They don't use their word anyhow. So when he repeatedly said, either an obiter dictum or observation, you say it's not the holding.
That is not the holding of the court.
Those that were sacked, that's the lead counsel. I mean,
if we said those were those and
that's the third applicant.
If we said those that were sacked, does that mean that there had not been an intervening event in which a court of appeal had ruled on that particular sack? For the fact that those who are sacked, is that a complete statement? Is that the complete judgment? I'm telling you that you have observation, you have a review of fact. We put fact before the court that we were sacked. Then the court will review it, and we use the same language. Okay. He may employ another one, but he will convey the same message. What I'm telling you is that what you just read is obiter dictum. It is not the holding of the court.
Observation.
Yes, the court observed. Even from the beginning of that particular paragraph, he said my observation. That is not the holding. Ask each lawyer that come to review the situation on ground now to go to the holding of the court. And you too go to the holding of the court, where the court said, I refuse the application. Just because we have decided on the same case with the similar facts, parties, and if I release this case, it's an attempt for me to sit on appeal against the one that had been decided. That is the ruling of the court. It's not the one you are reading.
All right. We are due for a break right now, and of course the conversation we continue is about the people, and of course the legality, constitutionality, and why something cannot be built on nothing. The APC are saying, as far as local government administration is concerned, they are the ones in charge. The PDP, on that, being led by the state government, or the state government rather, in which they have the PDP are saying we are the ones in charge. Stay with us. We'll broaden conversation for that. Thank you for staying with us, and we are still talking about the elephant in the room in Osun State. Who is really in charge, legally speaking, of our local councils? Yes, we have different developments, but today Osun people are asking that question. So that's why we are there today. And of course, we have the legal officer for the All Progressives Congress in Osun State, Barrister Adegoke Ogunsola. He has been here with us. Thank you, Barrister. And of course, joining this conversation is the special advisor to the Osun State Governor on legal matters, Barrister Nurudeen Kareem. Good to see you here.
Good morning.
Thank you for joining the conversation.
It's my pleasure.
Before you came, Barrister Ogunsola said the APC, legally speaking, nothing is, nothing is confusing. They are the ones in charge. We made mention of the June 13th election, ruling, and he said it's nothing special. And in fact, we are coming from the statement issued by the Osun APC, where they said only the Supreme Court can invalidate the appeal court verdict on restated ESCOs, and that's their position. Do you agree?
I don't, and of course that's a very wrong position. With the judgment of the appeal court rendered on the 13th of June, the matter is settled. I said it, I think, on this program maybe some days ago or somewhere else, that if there is still any argument today between the two camps, I think the argument is superfluous and unnecessary. Any argument now as to who is legally recognized as chairman of Osun Local Government should be ordinarily between the APC lawyers and their members and members of the public, laymen, who have themselves read the judgment on 13. It is clear enough. Any argument now, any purported confusion arising now is artificial. And it is artificial because it has been deliberately created by the APC just to have one excuse or the other for occupying the local government secretariat illegally. What is more? Yes, I'm saying it. What is more? Even in the lead judgment, as read by Honorable Justice Peter Obiora on the 13th of June, page 16, paragraph 2, the court clears it by saying that the dismissal of the appeal which APP filed against the judgment obtained by which APC filed against the judgment obtained by the APP on the 30th of November 2022 from the Federal High Court. The appeal filed by the APC against that judgment, the dismissal, the lead judgment is saying on page 16 now, the dismissal of that appeal simply means the legal implication of that dismissal is that the judgment remains binding. The judgment remains extant, remains valid, and it remains the authority. And if I will quote, the court in the late judgment is the one saying that that judgment remains the authority defining the status of APC yes or no chairman who was sacked by that judgment. It is very clear. We are not, they will always come back to the February 10 judgment. Yes. But we are still maintaining our position.
Just before you proceed, Barrister Kareem, you have made your points, and here's Barrister Ogunsola's argument. Well, he's not denying the fact that they were sacked by that court ruling. But here's his submission, and I want you also to shed more light into that. He said, fine, despite the fact that they were sacked, that the governor went ahead and gave an executive order asking them to vacate their office. That the governor shouldn't have done that the governor had no right to do that. Because citing the case of the governor himself, when he had a case at the tribunal, nobody sacked him from office. That he has the right of appeal, right to appeal. That nobody stopped him from that. That why would the governor go ahead to issue that order to sack them from their offices, despite the court's ruling that it is not constitutional? How do you respond to that?
Yeah. You see, the governor never did anything wrong in the face of the law. They are already been sacked. Ordinarily, upon the sack, their dismissal by the court of competent jurisdiction, they were supposed to honorably leave the corridors of power.
No, he said they have the right to appeal.
I'm not saying do not have the right to appeal. But there is something we call, there is a popular, the senior here is my nene senior. He's a lawyer. Of course, it's my nene senior. There's this principle, everybody, it is elementary in law, that even appeal does not operate as a stay. The meaning of that in law is that when somebody obtains a judgment against you and you go to the court of appeal, you file a notice of appeal. The fact that your notice of appeal is pending does not stop the beneficiary, the person who is the beneficiary of the judgment from reaping the fruit of that judgment. The only thing that will make the person not to reap the fruit of that judgment is you will go as a judgment debtor, as a judgment who has lost in the judgment. You will now go, after finding your notice of appeal, you will now go before the court that gave the judgment, or alternatively the higher court. You will file an application for stay of execution or injunction pending appeal, depending on the nature of the judgment. It is only when the court has granted that application, staying the execution of the judgment already obtained against you, that is when you can say we are on appeal. We cannot do anything about the judgment.
Because there's an injunction. There is
an injunction. Now, I am throwing this to my oga here. When the governor gave the order, didn't they file that application for stay? APC filed it. They will never tell people. I was in court the day that application was heard. APC filed, they filed a notice of appeal, and you cannot file that application for stay without having filed a notice of appeal. So your stay will actually rest on that notice. After they filed their notice of appeal, they now brought that application before the court so that they will enjoy the seats pending the determination of the appeal. But the application was rejected, was refused by the court. I must let them tell the whole world, as of today, in respect of the appeal filed against the APP judgment, in respect of the appeal filed against the PDP judgment, do they have any injunction or stay granted by any court for them?
All right, Barrister Ogunsola, please, you're hearing person, so I'd really like you to respond to that. This is clear legal issues. You filed an injunction which was not granted. Please,
I'll make some clarification before I say anything in respect of, and I want my learned friend to either confirm or deny it. Election matter is a class of case.
Yes.
Is a class of case. It has sui generis nature.
Yes.
And when you said it has sui generis, some principles which are ordinarily applicable in civil matters do not apply in election. It has its own principle of law, which is enshrined in the case law as well as electoral act and electoral law. Secondly, the issue of the injunction, the application for injunction is said we filed was as a result of midnight executive order. If there had not been midnight executive order, we don't need to file an application for injunction. Because the judgment was delivered on 25th day of November 2022. And immediately the governor was sworn in about 12:00 midnight. He made an order that he had sacked all the local government chairmen and the most senior officers to take charge. And that was why we filed the executive. The judgment was delivered on Friday. The governor was sworn in on Sunday. And that was why we filed the injunction on Monday or Tuesday, so that the executive order would not have effect. But what was the ruling of the court? The court said what you wanted to have injunction against had been executed. And as a result of that, an act that has been completed cannot be restrained. And that is the principle of the law. If the governor had not issued as executive order, what the law says is that we don't need to file anything. It's clearly written in the law that the person that is in that position is in the Electoral Act, the same Electoral Act which they rely upon to say that we have to give a notice of 1 year. It is in the same, that particular Electoral Act, which says that the person that is in position will continue in that position until he exhausts the right of appeal. But they don't want to rely on that. They only choose the one that is suitable to their situation and rely upon it. And what I'm saying in essence is that, you know, he who comes to equity must come to with clean hands. You don't issue, you know, and I want my learned friend to also confirm or deny. The judgment of the Federal High Court was declaratory in nature. It's not executory. When you have a declaratory judgment, you don't execute it. That is the principle of the law.
Barrister Ogunsola, you just hold on, Barrister Kareem. Barrister Ogunsola, you just confirmed what he said. You said you filed an injunction, and the court said that an act that has already been... Hold on, Barrister.
Yes.
This is law now. I'm not a lawyer, but I can interpret clearly what is going on, what you just said. You said you filed an injunction. Because there was a midnight, according to you, a midnight executive order.
Exactly.
And the court is saying that for an action that has already been executed. So it's the same thing.
And that is why we pursue our appeal. When we go to the appeal, then we pursue our appeal.
But,
and the appeal said...
Here's the point. The court said that action has been executed, which means you are sacked, you've been removed.
Then once the appeal is in your favor, you go back to status quo antebellum.
But the court did not undo that case. It didn't undo that execution. That's the point.
The court will
undo that. That's the question.
Execution will not be part of your appeal. It can't be part of appeal.
You know, I don't need to be a lawyer to understand this.
No, you are mixing it up. You are mixing it up. No. Execution was not part of judgment, and you cannot. If you want to go on appeal on execution, you do that separately. If you feel that the execution was not carried out in the way it should be. But what I'm telling you is that once your appeal succeeds on the substantive matter that led to execution, you go back to the situation you were before the execution.
All right. You know, before now, you were talking about...
Let me ask you some questions.
Okay.
Let me respond to that.
1 minute.
Now, my Oga said that nothing to execute in the judgment. When I was making my point, I made it in alternatives. I said either a stay or injunction pending appeal. When the judgment is declaratory, is not executory, that's why you apply for injunction pending appeal. If it is executory, you apply for a stay. I made it clear. Now, come to that. My guy said, I want to throw some questions to him too. No, regardless of the sui generis nature of election matters, in law today, and I'm saying it loud and clear, the elementary principle of law is that even when your appeal is pending, that appeal is one of the that appeal does not operate as a stay. It's a very popular, that sentence or phrase is very popular.
Regardless of sui generis.
Regardless of sui generis of nature. Now, to now bring an exception to that general principle of law, the Electoral Act 2022 now incorporates a provision, which is Section 138 of the Electoral Act. But that Section 138 is not telling you if it is an election petition matter. You know, we have some cases in Nigeria today that they are time bound. One of the features of the sui generis nature of election matters is that they are time bound. Time bound in the sense that look at the governorship election petition. From the trial court, from the tribunal to the Supreme Court, it will not take more than 1 year.
Okay. Because of time.
Because of time.
Yeah.
Because of time. Now, because they now make it that of a president, the same thing, that of a House of Rep, House of a member. Now, all those litigations that are time bound, the Electoral Act now brings a provision
Okay. Barrister, your point exactly.
My point is that that section now says once they have filed an appeal, they should wait until the matter is finally determined at the final court. Knowing that it will not take more than 1 year from the court of first instance up to the last court. Now the question is, does this matter fall within the purview of litigations which are time bound? They filed their appeal 2 years ago, 2022. We are still at the appeal court. You can see the makers of the law, they are not stupid.
All right.
So that is point.
Let me ask this question.
That basically what that says, it does not apply to this.
All
it
right.
only applies to litigations that are time bound. I've given you examples.
Point made. Now, the February 10 election, judgment, Court of Appeal judgment given in Akure, has been open to, people will say, is it that open-ended, open to interpretation from the APC, from the ruling party, from the state government? Barrister Ogunsola, let me ask you. And the APC have been heavily dependent on that to say that is where our mandate was, reinstated, that was given to us. In fact, that was the judgment the APC, Osun APC relied on, to go back to the councils, and they have been there since. Which part of that judgment reinstated the mandate that the APC are claiming to have?
When you go for an appeal, you set out your reliefs. Then you pray the court to allow your appeal. And once there is judgment, and at the conclusion of the judgment, the court says appeal allowed. And the court never said except relief 1, 2, 3. Said appeal allowed. It's a general statement. Your reliefs are allowed. One of our reliefs is restatement. And once the court has said appeal allowed, reinstatement has been allowed.
Barrister,
that's a technical one. That's a technical one. I quite understand.
The court does not differentiate.
The court differentiates.
Okay, do you have the judgment?
Now, the court differentiates.
The judgment.
When the court says, before the court came to that conclusion, the court clarified it. They formulated 4 issues. 2 issues were based on preliminary issues. Preliminary as to the fact that PDP filed their case before OSIEC published the notice. Those were the preliminary issues. Now, the remaining 2 issues, issue 3 and issue 4, are the issues that have to do with the substance of the case. What is the substance of that case? Whether a local government election conducted with 2 months' notice is valid or not, given the provision of Section 115 of the Electoral Act, the provision of 98 of the Electoral Act, the provision of Section 28, 32 of the Electoral Act. That is the case filed by the APP, the case filed by the PDP. The substance of 2 cases is whether election conducted in 2022 with 2 months' notice is valid or not. Now, if they are now, before the court ended that ruling, the court said, declined to consider issue 3 and issue 4, which deals with the substance of the case. And the court did not do that, and that was why the court never made any restatement order.
Barrister Kareem, hold on, Barrister Kareem. Let's get this very clear. Hold on. Barrister Ogunsola just said something now.
Yes.
He said the court granted the appeal without exempting any of the reliefs.
Exactly.
Without striking out any of the reliefs. That's what he said.
Yes.
Now, you are saying, what are you saying? That the court mentioned
the court exempted.
Can you
we have to get this very clear.
No.
Barrister Kareem, if truly the court did not pick on any of those reliefs, it means the appeal was granted. Unless you can prove that the court actually...
Now, I will ask you, why did the court mention deliberately that issue 3, issue 4, dealing with the substance of the case? I will not consider them. And the consideration of that issue would have led to a positive order, finding them truly worthy to be on that seat. Now, after the court said the appeal is allowed on the basis of what? Was it on the basis that the court of appeal found that an election conducted with 2 months' notice is valid? The court will not make that mistake. The court, why was it that then the court said they allowed? Didn't they ask? Was it not part of their relief that the court to strike out the suit filed by the PDP? It's part of their relief. Why did the court mention that one specifically? After allowing the appeal. After allowing the appeal, the court now said the suit filed by the PDP is now struck out. That particular order is one of their reliefs. Why did the court go ahead to single out, to specifically mention that it has granted?
Mr. Kareem, so if the court singled out some reliefs, why did the court not mention their relief regarding the aspect of state?
That's what I'm saying. That's what I'm saying. Because it is elementary law. And this is what the court is now telling them on the July 13th. That APC now brought the listing application in order to lodge the court to refute its judgment. The court knew they wanted the court to make a positive restatement order.
By Sakari, because of time. By Sakari, because of time. Because of time. So in 1 minute, because of time. By Ogunsola, please. By Ogunsola, please.
You don't know what they thought.
By Ogunsola. By Ogunsola, please listen to this. By Sakari, please, because of time. The court is very meticulous. He just said they mentioned some reason. I ask again. Why did the court did not touch that relief concerning the aspect of their request to stay?
The reason why the court did not was that you have in their issues, they have preliminary issues, they have issues that have to do with the merit of the case. Now, the court found that the preliminary objection they brought was enough to strike out the suit of PDP. So the legal implication in law with the appeal being allowed, which they are touting now, is that it is just as if PDP never went to court. PDP never filed any case. They meant something. The court did not even dismiss PDP's suit because the PDP suit is hereby struck out. After that, the court made the consequential order regarding cost. The court never made. Why did the court mention another relief after allowing the appeal? Why did this court just say the appeal is allowed? Another thing, it was part of the fact before the court was that they were no longer on that seat as at that time. If the court had wanted to restate them, the fact that they were no longer there, the court knew they will need a positive order to be over.
All right.
So that if anybody violates that order, the person can be held.
Almost out of time. Now, the position of Osun...
The court never made any order.
The latest position of Osun APC now, all right, is the fact that only the Supreme Court can invalidate the appeal court verdict on restated escorts. Is that your position, sir? Barrister Ogunsola?
Yes. The restatement.
So as far as you are concerned, APC is in charge.
Presently, I'm the chairman in Adegoke Local Government, with the headquarters at Ilobu.
Have you been working there?
Yes, I've been there.
What have you been doing?
Times. Yes, there was a time we evacuate some debt and so on and so forth.
For months, that's the only thing you've been able to do.
Yes.
The workers are at home. Who are you working with?
Some of them used to come to office. You know, they have been broken into two.
You broke them?
No, they broke themselves.
But so you have workers working with you?
Some of them are coming.
How have you been running the council?
Well, with the grace of God.
Grace of God, financially speaking?
Yes.
Are you being paid?
We are not. Because the governor had taken over wrongly the affairs of local government.
So if you have
the governor has forgotten that local government is an independent and distinct government or tier. So
as of today now, Barrister Adegoke is the chairman of the Adegoke Local Government.
Yes, I am the one.
And you have nobody working with you?
I have people working with me.
How many of them?
I cannot know the number because I don't count.
So until the court says otherwise, you're still the chairman?
I'm the chairman.
The court has already said...
We take this as a financial.
The court has already said otherwise we are expecting. If they are talking about the judgment of appeal court, before June 13, one of their reasons or their...
This is your final shot, please. We are totally out of time.
Was that the dismissal of APC appeal against the APP judgment came on in January. That of the APC came in February 10. So the later in time is now the appeal court has now had the opportunity of making another pronouncement, which is now the latest on the 13th of June.
So what's that latest?
In that judgment, the court does not, the judgment expressness recognizes that another people, the council is now legally occupied by PDP chairman elected on the 22nd day of February 2025.
We must thank you, gentlemen.
If anybody claims to be in council now, the Appeal Court has told them they are not legally recognized.
Are those people parties to the appeal?
All right.
Are those people?
That is a matter that the APC can go and
which you said we enjoy the fruit of that judgment according to your position. Are they parties?
We used to be going to the Supreme Court.
We cannot go to what? On academic issue.
The Supreme Court.
On academic issue.
PDP case.
All is done and dusted.
It has been dismissed.
So who will now decide this matter?
PDP is in charge.
The court, the APP case, court has said that why did they file 2 notices of appeal?
All right, it's all right. We must go.
PDP case
is different matter.
Ask them how many appeals
Barrister,
did they file in 2022?
Thank you very much. All right, now,
why did they file 2 appeals?
Assistant Barrister Ogunsola, you said you are the chairman of Adegoke Local Government.
Yes.
Under the flag of the APC.
Not under the flag.
Yeah.
Because once you have won the election, you put flag somewhere.
Okay.
I'm the chairman of PDP and APP in the Adegoke Local Government.
Okay.
So please permit me to ask my guy a question.
No, you have no permission again. We'll do that sometime.
So that telling us that a 2-month election notice is valid.
All right.
I'm asking my lawyer.
That you have to go back to court. Once our appeal has been allowed
to go back to court, saying
you go back and
you have the latest judgment.
Your suit at the
who has the latest judgment?
Your suit at the Federal High Court was struck out.
Thank you very much, gentlemen.
Is it
content proceedings are waiting there now. Content proceedings at the Federal High Court.
Yes,
thank you.
You will meet us there.
Thank you. Now, Barrister Adegoke.
I'm one of those who are cited for content.
Barrister Ogunsola Adegoke is I crave your indulgence, gentlemen. I crave your indulgence.
We really have to go.
Barrister Adegoke Ogunsola is the legal officer for the APC in Osun State.
And the chairman in Adegoke Local Government. You have refused to add that.
You said it. All right. The SA legal to Governor Adeleke, Barrister Nurudeen Kareem. Both of you are learned professionals. You know, we are the
that is impersonation.
You said
we are not learned sick.
You are learned professional. You are lawyer. Okay, it's all right. Now, Osun people, the APC is in charge. The PDP is in charge. But the local government administration is comatose, grounded. Nothing really is happening. All right, we'll see you tomorrow. Make do of what you want of these, these submissions by these gentlemen. I want to sincerely appreciate everyone that has worked with us all through the week. You can have, this program and more on our YouTube channel at Western Spring TV. We're always live. And of course, we're on channel 190 on StarTimes TTT. Thank you very much.
And of course, Emeka Dana is my name. Thank you for joining us again. 2 lawyers from both parties have spoken. Clearly, both of them have valid points. Only a court can decide. I will not decide. They sincerely have valid points. Please join us again next week for fresh editions of Morning Spring on Western Spring Television. Do have a wonderful weekend. Good morning.